Okay, I'll give that in mind on the different slides. All right, guys, let's wrap up. So Ms. Marchese, I think, just made a good point that some of the material that is introduced in this lecture you may have encountered before in your history classes, things like Brown versus Board of Education, for example. So please stop me and let me know if I'm reviewing something that is obvious and you guys already know. We'll try to focus on the law, which I don't think you guys have learned before. Okay, so let's start this discussion about training integrated schools for equal educational outcomes. Okay, so who'd like to go first? Yes, Henry, please.
I said I wouldn't trade it.
Okay.
Because even though it's the equal opportunity that's guaranteed, that's not something that I would be proud to give up. But at the same time, having a segregated school system, you would take away from students learning about cultural diversity and stuff like that.
Very good, very good. So diversity, cultural diversity, is something that is valued in the classroom. It's something that we're actually going to. It actually was used as justification for some of the more recent sort of affirmative action and integration decisions. Very good point. We will talk about that next week as well. Anyone else? Please, Amber. Actually, I don't think I called you last time. What's that?
Actually said the same thing you said.
The exact same thing?
Basically.
Word for word?
Well, I said it gives us a chance to learn about other cultures and religions.
Interesting. So you guys said cultures and religions distinct from races, right? So do you guys think there is a distinction there? For example, if you had African Americans and Caucasians with the same culture, can you have them with the same culture, and would that, obviate the need or get rid of the need for having integration? Is there something valuable about just having different people with different colors in the classroom?
Yeah, there is.
Why do you say it?
I think even though school systems, if they were the same, and kids would still feel inferior if they were separated.
Mm-hmm.
Also, if they weren't separated, they'll be ignorant about each other's races.
Okay, so even the same outcomes, so the same test scores, you still think that they would lose something and feel inferior?
Yeah.
Okay. Yes, Robert.
I think the same way with DC. I think like separating students based on ethnicity is bad because it promotes, like, say the white kids get better test scores than the black kids, and they'll think the black kids are inferior to them.
Yeah.
They'll think they're worth more. But if you mix up the colors and races and ethnicities,
Yep.
then that allows students to learn from each other.
What if they segregated the schools and the black kids all got better test scores? All the black schools had higher test scores.
It's still the same thing than the white kids who feel inferior to the black kids.
Good point. Yeah, Carly?
That was kind of like my same thing. Even though I feel like even if they got the same academic tests and they learn the same things, the same pace, they would still be losing life skills to deal with different people and everything.
It's a good point. So perhaps if we define educational outcomes as test scores, then you're still losing something because, let's be honest, outside of school, the world is not a standardized test, right? Maybe the ability to interact with people of other races is something that we should value. Shelby, do you have any thoughts on this?
Nothing that was already said.
Okay. Does anybody have the contrary position? Or just to be contrarian, can anyone sort of make the case for the other side? I just want to say this is not a ridiculous position. People today have sort of made this position not so much that we want to enforce segregation, that we don't want to spend so much time worrying about integration, right? That it's more important to focus on the quality of the schools than it is sort of the racial makeup of the schools. So instead of having de jure or segregation by law, if we have de facto, that is segregation just based on sort of the facts on the ground because people live in different neighborhoods, then maybe that isn't the worst thing in the world if we can guarantee this, equal educational outcomes. How do people feel about that idea? Yeah, Robert?
Well, if you can guarantee that everyone's getting the same education, then it's not that absurd.
Mm-hmm.
But there is no way you can guarantee that people will receive the same education.
Right, I think that's absolutely true. Let's say obviously it is kind of absurd, but let's say you could guarantee, is there still something lost Is there still something lost by not encountering other races, even if, again, it wasn't required by law that schools be separate, or the races be separate, they just happened to be, and we could guarantee that that they were getting the same education. Yeah, Henry.
I think the quality of the education would differ, because we can get the same education, but it's like, I think it would be better if we had a hands-on experience. If you know what I mean.
So you're saying, again, like even though you have the same outcomes, even if you have the same sort of quantitative scores, you still might be missing something that you can't really measure, some kind of quality education. Yeah, good point. Okay, so let's actually just jump into the history of it really quickly.
Can I just jump in 1 second?
Yeah.
Before we get to the history. This second half of this quarter, and even the first half of the next quarter, you're really starting to talk about contemporary issues that have two sides, issues that are being litigated on both sides, that have social perspectives on both sides. And so we're going to ask you to be brave and jump in on sides that may not seem politically popular or even socially correct, because it's part of this sort of academic dialogue that you're having here. And we are all, I think, we've established a safe classroom, and we respect one another's views and understand that sometimes we may be arguing something that we wouldn't personally believe, but we want it for the sake of the interest of the discussion. So, because we're going to get into lots of these issues, this is simply one of them. And just remembering last year, you start to find yourself saying things that you might not exactly believe, but again, you're kind of in this dialogue of give and take. So we want to encourage you to do that. If at any point you feel uncomfortable with what's being said, let us know. But be brave.
Yeah, and we won't have the camera turned on for most of the other. So when Nicole or Henry or whoever is running for governor in 30 years,
Right.
we don't have to. You don't have to worry about this tape coming out. Okay, so here we go. All right. So just the quick history, and again on Ms. Marchese's point, you probably have seen a lot of this before. Very quickly, sort of the history of slavery. This is a map of. What is this a map of? This is a map of early. This is a map of the United States at the time of independence, and again, 13 colonies became the states, and slavery, I believe, was prevalent everything south of Maryland. Although there were people who were holding slaves or had slaves with them in some of the other states, which is what the next case, the Dred v. Scott case, is sort of about. So the Constitution, as we talked about actually yesterday, sort of made this bargain with the devil, because the northern states wanted to unify the country under the Constitution. They had to make certain compromises with the slave states, and one of those compromises was this 3/5, the other persons. And what it did, as we discussed yesterday, was it increased the representation of the southern states. Because the slaves could not vote, but were counted, that meant that every person, every sort of white slaveholder, every white person, every free white male in the South, their vote counted more. Their vote basically counted for 1 plus 3/5 of a vote in terms of representation. Let's see. Oh, right. Also, one of the only, so Article 5, as we talked about last semester, Article 5 allows for amendments in the Constitution, except for, in Article 1, Section 9, there was like an unamendable clause. There was a clause that says, you cannot change this before 1808. And the clause was, you cannot ban, basically you cannot ban the importation of persons, the importation of slaves until 1808. Again, it was just a compromise to get the southern states to come along and to sign the Constitution. And the last thing, fugitive slave clause, which sort of ties to, let's see if we can do, ties to the Dred Scott case. And so there were laws in the United States that, first of all, slaves were property, not people. And when they escaped to the North, there were laws that required the people of the North to return them to the South, or at the very least, allow Southern people to pursue them into the North and sort of grab them and take them back to the South. Have you guys, can we just have a show of hands, who has heard of the Dred Scott case before, or maybe studied in your classes? Okay, so Terrence, have you not, or are you just tired?
Until I read the book.
Okay. All right, great. I actually, interesting enough, I don't think I ever heard of it when I was in high school. I might have not even heard of it through half of college for some reason. But that's just because I'm from the backwoods. Anyway, so yeah, the Dred Scott case. So this is Dred Scott. Quick history of the case. He was owned by a man who now escapes me, who was from Missouri. and they traveled together. I believe when his owner was in the military, they traveled to either Wisconsin or Minnesota, and also to Illinois. And these were free states because of something called the Northwest Ordinance, which was passed in 1787. It was legal for slavery to be introduced into the states northwest of the Ohio River. So while he was in these free states, there's sort of this question of, is he free, is he slave? But then he went back down to Missouri with his master, to Missouri and then to Louisiana. His master married and then died. And actually, Dred Scott also had married at this time. And it was not uncommon for when someone's master to die for the practice of called manumission, or am I pronouncing that correctly? Yes. Where in the will, or the slave would be freed, or the other people in the family would free the slave. And so Dred Scott asked the wife of his former master, to please free him, and she denied his request. At the time, they were living in Missouri, and he sued in Missouri court based on the idea that he had been freed. He has been freed when he was brought to those free states. And he unfortunately lost there in Missouri court, and later brought another case in federal court based on what's called diversity jurisdiction. Because he was, I believe his master at the time was living in New York or something along those lines, there was some issue where because people were living in different states, he could sue in federal court. Okay? So he sued in federal court. Yes, Shelby?
Wasn't there another case that was similar to this one, Marbury versus Madison?
Marbury versus Madison is a very important case, but it's not really similar to this one. It's one of those original cases that it's similar to this case in that it was decided in the early 1800s, and it's a very important case. But Marbury versus Madison actually dealt with well, it's kind of a complicated issue, but it dealt with federal appointments, and it dealt with the ability it stands for the idea that the court can strike down a law. So yes, it is connected to this insofar as once this got to the Supreme Court, Chief Justice Taney, he wrote a decision that said, first, slaves can't be people. Slaves can't be citizens of the United States. Yes, Robert.
Marbury versus Madison, that was about the midnight decision, right? Where the president is.
Right. Right. Well, I mean, let's see, it was the midnight decision.
It was the Midnight Judges Act, yeah.
Yeah, with the judges. That's right. But Shelby is correct in that Marbury v. Madison laid the groundwork for Taney to strike down a congressional law. The congressional law was what's called the Missouri Compromise. The Missouri Compromise brought Missouri into the Union as a slave state and Maine into the Union as a free state, and then banned slavery northwest of the sort of northwest of Missouri. And these are all connected because one of the things that Taney said was, if you take away someone's slave, you are taking away their property. And this is illegal under the Due Process Clause of the Fifth Amendment of the United States. And I know these are all kind of big legal terms, but we're going to come back to them again and again. So I just want you to have that in your head. Due process. So it's kind of it's something that you're going to hear again and again later in this course, but due process is something that actually, I guess unfortunately, started in the Dred Scott case. Okay, so yes, and so it struck down this law, and it made him a slave, or kept him as a slave, and it further held that that basically black people could not be citizens of the United States. And this case enraged the abolitionists. So here's just another quick map. So again, the Missouri Compromise brought Missouri in as a slave state, Maine in as a free state, and then banned slavery in this territory. And that ban of the slavery in this territory is what was struck down by Chief Justice Taney. To sort of defend Justice Taney briefly, he thought what he was doing was he thought he was going to try to settle the slavery issue so that people would stop debating about it and perhaps it could avoid further conflict. Unfortunately, it had the exact opposite effect. People were really upset about this. People in places like Illinois and I guess Minnesota wasn't a state yet. Maybe it was still a territory brought him there. But at any rate, it upset the abolitionists, people like Abraham Lincoln, for example, and it was one of the causes of the Civil War. Wait, why is it? Okay, sorry. Okay, very quickly. Oh, there it is, on there. Yeah, so we fought a Civil War, obviously. During the Civil War, President Lincoln, I almost said President Clinton, but President Lincoln issued the Emancipation Proclamation, which said that the slaves in the Confederate territory, at least, were free. There's some actual legal debate about whether he had this power. It's not clear the president has the power to do this, but at any rate, people respect it, and that's good. And then we fought the Civil War. Fortunately, the slave states lost, and it led to so that the war ended in like 64, 65. And they let in 64, we passed these series of constitutional amendments that changed the Constitution. The first one was the 13th Amendment. The 13th Amendment banned slavery in the United States forever. The 14th Amendment, though, so even though the slaves were free, the Republicans in the North, the Republicans being the party of Lincoln, recognized that people were still going to really abuse these free slaves in the South. And in places like South Carolina, slaves actually constitute a majority of the population. And so they said one of the ways they passed this amendment was by saying you are not a Republican state. You do not have a Republican state in your government. I'm sorry, you don't have a Republican government in your state. So we're not going to let you back into the Union. That is, we're not going to let your representatives back into the Congress until you pass this 14th Amendment. And so the 14th Amendment contains a number of clauses we're going to be discussing in the following few weeks. But one of them is Equal Protection Clause. Let's have somebody, Terrence, could you please read that? 14th Amendment.
Equal Protection, 14th Amendment, Equal Protection Clause, nor deny to any person within its jurisdiction the equal protection of the laws.
So, originally, and we're going to talk about this a lot more, but originally it was...
By the way, the beginning of that sentence is no state shall, and then it lists several things that states aren't allowed to do, and then it says no states shall deny to any person.
Oh, excellent. So, but that's a very good point by Mr. Riley. So the original Constitution, as you know, in the Bill of Rights, did it apply to the federal government or the state government?
State.
Yeah, so, no. Sorry, you had me there for a second. No, it applied to the federal government. A couple of the provisions applied to the states, but by and large, the Bill of Rights, for example, applied only to the federal government. The 14th Amendment specifically said, no state shall. No state shall do this or that. It applied to the states, okay? And this is a very important point. This fundamentally changed the way the Constitution applies to the states and the federal government. You could even say this is one of the most important, this might be the most important, and it's certainly one of the most important amendments in the United States Constitution. It's one of the most important moments in American history. It's like a refounding. It's one way to think of it. I mean, it fundamentally changed things. Almost as much as the Constitution itself changed America, the Reconstruction Amendments after the Civil War sort of refounded American law, okay? So if you ever hear people talk about, oh, you know, the Constitution was only supposed to apply to the federal government, and all it does is limit the federal government, and, you know, states governments can do what they want, you say, no. We fought a war about this, and the people that won said that this is not what we do, right? That we're going to change the rules of the game, and the states will also be subject to the Constitution. And then there was finally a 15th Amendment as well that protected voting rights. Unfortunately, as you guys know, and as we're going to talk about here in a minute, these were kind of dead letter. They had these amendments, but really they weren't enforced. After Reconstruction failed, they established a system of Jim Crow, which I'm sure you guys have heard of. It's just sort of very broad and deep system of segregation and oppression of the freed slaves. And so the 15th Amendment, even though there was a 15th Amendment that said people should be able to vote, there were all these laws passed, like literary tests and poll taxes, and straight up just intimidation that prevented people from voting. Also, Plessy v. Ferguson. So Plessy v. Ferguson, I think you guys, has everybody heard of Plessy before? Raise your hand if you've heard of Plessy v. Ferguson before. Okay, so not everybody. Have you heard of it before, Robert?
I'm trying to think what's the one.
So it's about a. It's interesting. This picture is actually kind of wrong. Plessy was, what was it? Plessy or Ferguson? It was Plessy, right? So Plessy must be a very light-skinned man who was only like 1/8, something like that, black or 1/4.
He was an eighth. He was part Creole.
Okay, he was Creole in Louisiana, and he wanted to ride in the in the white section of a train, and he was prevented from doing so, and he sort of sued on. I think he was fined, and he was challenging the constitutionality of this fine using the 14th Amendment, and unfortunately. In Plessy v. Ferguson is sort of the leading case that upheld this idea of separate but equal. This idea that the Equal Protection Clause says that if you can keep people separate so long as you just treat them the same, as long as you have the laws that apply to everybody the same. Just sort of what we talked about yesterday. Remember with Loving v. Virginia, the law bans both white people and black people from marrying people of the other race. So what's wrong with that? It applies the same, right? And but Justice Harlan. Who was actually a conservative justice and did some things later that were probably people weren't terribly fond of, but he gave this sort of very impassioned and stirring dissent where he said, we are doing a terrible thing. This is not what the people who framed the 14th Amendment intended. And actually, this is last year. Nicole, could you read from Harlan's dissent, please?
Our Constitution is colorblind and neither knows or
Nor.
Uh-huh. I can't see now.
Oh, okay, sorry. Leah, could you read, please?
Our Constitution is colorblind and neither knows nor tolerates class among citizens. In respect of all civil rights, all citizens are equal before the law.
Okay, so unfortunately, this is dissent, right? And Plessy v. Ferguson upheld this notion of separate but equal, which was basically prevalent in the law of the states for the next 60 years, actually for the next 70 years. Although, so in the 1940s and 50s, a group called the NAACP, which unfortunately got cut off here, but I'm sure you guys have heard of the NAACP, began litigating. They began, through lawsuits, challenging this notion of separate but equal. And one of their first cases was called Sweat v. Painter. And it basically said that, I think there was only one law school originally in Texas that black people could not attend. And then Texas set up another law school. They got sued, and so they set up another law school. It was kind of a fake law school. It wasn't really a law school. Nobody respected it. Nobody had heard of it. And law schools, for better or worse, are based a lot on reputation, not quality of education. If Yale Law School has taught us anything, so they sued and said, this is nonsense. You can't put people in this fake law school and say it's the same as the real law school, the University of Texas Law School, which is quite a good law school. And they won. They won this case, and the Supreme Court said yes. This is nonsense, and we're not going to allow it. There was another case called McLaurin, Mr. McLaurin, although I don't think he was involved. So the same thing for graduate schools. And then, law schools, graduate schools, these are important victories, right? But they don't touch on sort of the fundamental, the experience of most people in the country. Yes?
So was the Texas Law School private or public?
An excellent question. It was public. That's a very good point, right? So the idea, and actually this was controversial well into the future, and it's even kind of controversial today. Can a private institution be segregated? Can a private institution have these laws? But that's exactly right. State action, right? There was a state actor, and it's a public institution paid for with tax dollars, so it's held to a higher standard, right? Very good point, Robert.
Private schools can though, right?
Well, that is controversial. So many private schools are tax exempt. So the idea is that they get tax breaks, they might still be held to certain laws. There are ways to sort of connect private institutions to the public space and to make arguments that a private actor is actually a state actor or has some connection to a state actor. In these cases though, it's not really, that's something we'll talk about much later, I think, in the semester. In these cases, it's pretty clear these are all public institutions, right? And so we get to Brown v. Board. So again, the NAACP, they had a strategy. They weren't dumb. They thought, we'll start with sort of the easiest case to win, the law schools, where it's clear we're being abused. And then we'll go to grad schools, and then we'll win a couple other small victories, and then we'll take on sort of the holy grail. We'll take on the real edifice, the real large, sort of system that is affecting the country. And that would be, of course, public high schools and elementary schools. Okay, quick, very quickly. Which amendment bans slavery in the United States? Carly. The 13th, very good. Which amendment contains the Equal Protection Clause? Henry.
14.
The 14th, yes, very good. Which case upheld the practice of separate but equal? Shelby. Last question now.
15.
No, not name of amendment. What was the case name? Yes.
Plessy versus Ferguson.
Very good, yes. Plessy versus Ferguson. Very good. All right. So, the NAACP, led in part by this man. Anybody know who's this guy? Thurgood Marshall. Very good. I know it's on the screen. It's also my favorite name for an airport in the United States. It's Thurgood Marshall Airport in Baltimore. I just think it's a cool person to name an airport after. So, yes, Thurgood Marshall was their chief litigator, one of their chief lawyers, and he had this strategy, he and some of the other leaders had this strategy of winning these different cases and then challenging the high schools and the elementary schools. So Brown v. Board of Education arose in Topeka, Kansas. It was a class action lawsuit. So a bunch of parents got together with the NAACP and sued together. This is an important point about the Equal Protection Clause. The idea is, and certainly how it's developed today, is that it protects classes or groups of people, not just individual people. It protects groups of people. Okay. Now there's argument to me that substantive due process, which we'll be talking about later, protects individuals, where equal protection protects groups. Now, it's actually not as clear a line as that makes it sound, but it is important to understand that equal protection sort of centers around the idea that there are oppressed groups of people, not just one individual person. Okay? And so they brought this as a group, and they went to the Supreme Court, and actually, it's a really interesting history. There have been many books written about the case itself. So it was a much closer case than it looked. It was eventually unanimous. It was a 9-0 decision. But the justices were very hesitant to just sort of impose their will upon the states and upon the federal government, and overturn legislative acts. For exactly what the case that Shelby was referencing, Marby v. Madison, gave the Supreme Court a ton of power. But if you think about it, I mean, how did they use their power in the past? They used it for this Dred Scott, right? Which is not a well thought of decision. They used it later for a case called Lochner, which is today not respected, that struck down like labor laws. And so they were very hesitant actually to do this, to take the power of the court and overturn a democratically elected legislature. And there was a conservative justice named Vinson, who was sort of a powerful advocate for this side. But he died. He died while the case was sort of rising up through, I think it had actually already been accepted. He died, and he died in 1953. And he was replaced by President Eisenhower with Earl Warren. Now, Earl Warren was a Republican, but he was a progressive. He'd been governor of California. And he was, let's say, he was not kind of constrained by these same ideas of judicial sort of reservation. He was much more, so I guess the term today would be activist. He was much more like, no, this is right, we should do this. And he organized the people together, and he was sort of a powerful advocate for getting the justices on board, and eventually it was a unanimous decision. And it was, I think, you guys have read about this before, but it was sort of what you guys were talking about at the beginning of class. So Robert and Henry, and I think everybody touched on this idea that even if you have separate facilities, even if you say that they're exactly the same, and the same amount of funding and the same quality of teachers, there are still intangible factors. There are still factors that make them inherently unequal. And one of the biggest ones, of course, was in the 60s, and actually this is the 50s, there was no two ways about it. Everybody knew this was a system used to make black kids feel inferior. That's what it was used for. I mean, that was sort of, maybe that wasn't the purpose, but that was what the result was. And everybody knew it, and there was a series of sort of sociological studies that people like, that the NAACP brought. Have you guys heard of the Dahl study? Mm-hmm. Yeah, so the Dahl study was actually cited in this case. And it was a very controversial point, because up until that point, there were relatively few cases where people were allowed to introduce sociological evidence, like sort of that kind of social science, psychology as evidence. This is one of the first leading cases to do so. And it overturned Plessy, and it said, you shouldn't have segregation in the schools, but it didn't provide a remedy. That is to say, it didn't really explicitly force every school to desegregate immediately. And the reason was, the justices knew that the Supreme Court has no army, right? The Supreme Court has no real way, they have no money to withhold from the states. They have no real way to force states to do things. They only have their credibility, right? And so, unfortunately, though this was issued in 1954, the sort of system of segregated schools persisted in the South and elsewhere for another decade at least. And some would argue that it's even longer. I think in 1960, I want to say that 2% of black students attended non-segregated schools. It was some crazy tiny amount. So even 6 years after this decision, there was still essentially at least de jure, at least de facto rather than de jure segregation in the southern school system, and actually in the northern school system as well in some parts. Does everybody, just before we move on, let's just make sure we know what is the difference between de jure and de facto? I've said it a couple times today. I know we're
doing this on Thursday, actually.
Oh, okay. Well, never mind then. On Thursday, we're talking about de jure and de facto. But remember, from last lecture, remember yesterday, we touched on this idea of rational basis versus strict scrutiny. And we're going to talk about this more next week, but I just wanted to make sure everybody understood this as we move on. This was in the reading, right?
Yeah.
This strict scrutiny. So let's just, Henry, can you see okay? Can you read from the top?
For a race-based law to be upheld, it must survive strict scrutiny, and it has to contain a further compelling government interest, be narrowly tailored to meet its goal. Okay. And
that's okay. That's okay. So we need to read that last question. Okay, so this is the idea. For a race, after Brown versus Board of Education, and as sort of it's developed in the last 40, 50 years of law, race is a suspect category. If you are making a law that recognizes somebody's race and divides people by races, you better have a dang good reason for it. Because we know enough, the courts know enough now to understand that this is kind of a meaningless category that people are using. It doesn't actually signify anything in terms of intelligence or education or ability. It's just something that was used in Jim Crow and prior to that and during slavery as a sort of marker of worth, right? And so that was why they set up this strict scrutiny test. The strict scrutiny, again, let's just be clear of who is scrutinizing what. Yes, Rob. Ooh. Yeah, I'm sorry, go ahead.
Is it possible to separate people by religion?
What's that?
Is it possible to separate people by religion?
By religion? So I believe religion also has a strict scrutiny test. So that's a great example of it. So there are other categories, right? There are categories that we can sort of base laws on, separate people by. One might be religion, one might be race. Those are two that have strict scrutiny. Gender, actually kind of interestingly, gender is not a suspect category in the same way. It's not strict scrutiny, although there is sort of intermediate scrutiny. We'll talk about this later. But gender is another way to separate people. What's another way you might separate people? Can you think of any other sort of...
Money?
By income, right? So you might have, you can make an argument that a toll road, for example, sort of does that, or that there are different laws that sort of apply to progressive taxation, for example. So if you make a certain amount of money, your tax rate is different than if you make a lesser amount of money. That is not a suspect category in the same way as race is, because the Supreme Court has held, but also just sort of our laws sort of state that there are rational reasons for making those distinctions. Okay, that's rational basis versus, I guess you could say irrational, but this categorization is suspect. And so you have strict scrutiny. That is to say, who is scrutinizing what? The court, so let's just be clear about this. The court is scrutinizing laws passed by, Terrence, keep your head up. The court is scrutinizing laws that are passed by Congress or by the states. Okay? And the court has the power, because of Marbury v. Madison, to strike down acts of Congress. To say, you fail this test, therefore this law is null and void. This law is no longer the law of the United States. Okay? So let's ask this question. Why does school segregation fail this idea of furthering compelling government interest and being narrowly tailored? narrowly tailored means it doesn't sort of affect, doesn't have effects beyond its very sort of narrow purpose. Okay, Carly, do you have any thoughts on why would school segregation fail this strict scrutiny test?
Because because the effects of segregation, segregating the schools, wouldn't just end right there in the classroom. They would go on for a long time.
Very good. So that's why it might. That is one of the reasons it might fail the second prong of this test. Why might it fail the first prong? Anyone? Amber, why do you think it might fail this first prong, the practice of school segregation? By the way, do you remember any cases from the moot court that had this idea of a government interest? Do you remember the name of that case? Where they were burning. O'Brien, very good. So in O'Brien, remember, he was burning draft cards, and they said this is contrary to a compelling government interest, which in that case was, sort of the Vietnam War, basically. Yeah, Robert.
The 14th Amendment.
So the 14th Amendment, is why we have to do this test. The 14th Amendment is why this test applies to the state practice of school segregation. But I'm looking for, so let's rephrase this question. What is the government's interest? What is the state's government interest or the city's government interest in segregating people by race? What is their interest in keeping kids segregated by race in their schools?
They want to lose out on kids getting. What was their interest? The state said something, right, about
it's a good question.
Protecting kids.
Yeah, so that might have been.
No, from the Loving case, some that.
Oh, so you're talking about from the Loving case from yesterday.
Kind of the same reason here, right?
Right. So in the Loving case, it was the idea that we want to prevent race mixing because it'd be so tough on the kids later. Right. Yeah.
Viewpoint diversity.
What's that?
Viewpoint diversity.
I like how these just words that we've taught you. Yeah. Viewpoint diversity. Okay, it's funny you bring that up. Viewpoint diversity is a compelling government interest under some of the cases that we're going to talk about in like 2 or 3 weeks. I think you'd be hard pressed to make a case that keeping kids separate by race furthers viewpoint diversity.
I'm the opposite.
Right. So yeah, you're making the argument on the other side, right? But I'm not asking you to try to imagine what could possibly have been. It's hard to do, I think, now because we don't really see. It's hard to put ourselves.
Racial tension.
What's that?
Violence, racial tension.
Yeah, very good. Yes, very good. So one of their arguments might be, look, if we mix the races, or if we try to get rid of this system, there's going to be violence. There's going to be, and actually there was violence, right? We know this from the history. There was a lot of violence. So that's good. That might be one. Another one, I think, getting on what DT said. I don't know if they actually explicitly said it during the case, but there was undeniably sort of this underlying thing of we want to prevent white and black kids from getting to know each other and then maybe falling in love and maybe having kids, or having kids themselves. Like they were trying to prevent this race mixing. That was one of the actual reasons. I'm not sure if they actually presented it in the case, but that was sort of the real reason they were doing it, or one of the reasons they were doing it. Okay, so this is kind of a difficult question, but just really quickly, can someone try to sort of restate the Equal Protection Clause and what it does? What does it mean in your own words? Let's hear from someone else. Leah. Sorry.
Kind of that the laws have to be applied equally and fairly to people regardless of the race or religion, things like that.
Very good. So the law has to be applied equally and fairly. Now, do you think, for example, a ban on interracial marriage, it affects both races equally, and I don't know if fairly. I mean, does that sort of meet that test, that standard?
Well, it kind of meets the standard that I set, but in terms of the Equal Protection Clause, I don't think it does, because the Equal Protection Clause also infers freedom for diversity in terms of allowing people to have, it says you can't limit the life, liberty, and that, so I think forbidding interracial marriage falls under that.
Good. So you're saying there are other parts of maybe the 14th Amendment or the Constitution as a whole that maybe apply through the Equal Protection Clause and prevent laws like interracial marriage bans. Yeah, I think that's probably true. Anybody else sort of want to try to? I think we did a pretty good job. But anyone else want to try to sort of restate what the Equal Protection Clause means today?
I don't think the interracial marriage thing violates the Equal Protection Clause, but I think it's wrong, like morally wrong.
Okay.
Yeah.
This is a very good point, right? Something can be morally wrong and not illegal. Morally wrong, but not contrary to the Constitution, right?
Yeah.
That's absolutely. I mean, that's absolutely true. And that's a case, and that would be the case that the state in Virginia would have made, right? In Loving, Virginia, they would have said, yes, you in the North, you northern elitist judges, you might think this is wrong, but that's not what the Equal Protection Clause means. The Equal Protection Clause means that that laws apply equally, right? This is not how the Equal Protection Clause is today interpreted exactly, though. Today, it focuses on groups, and it also focuses on sort of what actually the result is, right? So you can say, yes, the segregation laws applied the same to both blacks and whites.
It wasn't right.
What's that?
It wasn't right.
Well, first of all, it didn't actually apply the same because they didn't fund people the same. But they said explicitly in Brown, even if you did apply them the same, the jig is up. Like we're not going to be fooled by this. We know that the actual sort of intangible effects are an unequal application, unequal result of these laws. Okay, so we're going to talk about this much more on Thursday. Mr. Riley will lead a class talking about sort of the results of Brown. After Brown came down and some of the court tried to integrate certain schools, there was this thing called massive resistance, is sort of usually the term, where you had violence, you had governors like standing in front of schoolroom doors or schoolhouse doors. You had almost a decade, or even actually more than a decade, of basically people in the South behaving, and actually in the North and on the border states, behaving very badly and not allowing this desegregation to happen. So this is, I believe this is in Little Rock. Mr. Riley, can you say? What's that?
The Genus 6 is recent. You're thinking of the Little Rock 9. A lot of southern cities followed by numbers.
That's right. There was
close.
Little Rock 9, and then there was Genus 6. I don't know which of these. Well, Genus 6 was a university, right?
Well, Genus 6 was a high school. It was like in 2006, though. It's not. That's not an integration
now,
case.
Now you got me on camera looking like an idiot, Robert.
No. We can edit this. We'll edit this.
Yeah, I think it's the Little Rock 9. But yeah, you can see they have to protect them with soldiers. These little girls and a young man are just trying to walk into a schoolroom or walk into a schoolhouse, and they have to protect them with soldiers because people are so upset that people are throwing stuff at them and spitting on them and yelling at them, and it's kind of, I mean, for myself studying this. I assume it feels the same way for you. It kind of seems like another world or like another universe. I can't imagine why people would be throwing stuff at like 14-year-old or like 12-year-old kids just because they want to go into a school that was segregated. It's just kind of like disconnected from my reality. Yes, Robert.
Well, I don't necessarily agree, because you got to think about like the majority. It's easy to follow somebody and do what they're doing, like especially when it's a lot of people. Then to like stand on your own, like what if you were like the only white kid in the crowd saying like don't hit them or don't spit on them or like let them into the school? You would get beat up too. Right.
That's a very good point. Yeah. So you're right. So it's not like everybody in the South was guilty of this. There were people that were certainly, as you point out, just sort of afraid. I guess my point is that why were people like beating and yelling and screaming and like those? Maybe it wasn't the majority of people. Maybe it was just a loud minority. But why were they so upset? It seems so unusual to me today. But at the time, in the 1950s, 1960s, it was kind of the like central fact of their universe, of their civilization. It was just that. I mean, segregation was what the South was built upon, and to a lesser degree, what the North was built upon. De jure and de facto segregation. Okay, so very quickly, because we want to get you into your sort of we're going to have you guys debate amongst yourselves. This idea so this says, sorry, it's got cut off. Did Brown really change history? So was it Brown that sort of led to the civil rights movement? Because a decade later there was the marches and everything, and eventually this all came down. Was it Brown that sort of caused that, or was Brown just sort of one step in a long and gradual process? Right? Let's just read through this. Amber, could you read here, please?
Most scholars think of Brown as a turning point. The court pushed
The court pushed change and transformed the country.
Carly, could you read the second paragraph?
Some, however, argue that the desegregation would have proceeded more smoothly without the court interfering and have been more democratic.
So the idea is that the and this probably is true, that this is undeniably true, that the Brown decision really motivated a lot of resistance in the South. And so where you actually had some racially moderate segregationists, in the sense that they weren't aggressively racist in some of the southern states. Big Jim Folsom, I think, is one of the most famous. I think he was in Mississippi or Alabama. People like him lost after Brown, because people in the South pointed to Brown and said, look, it's like Reconstruction. The federal government's coming in to our states again and telling us what to do. And so they elected these radicals. And the radicals, like Orville Faubus, the second time or the fourth time he was elected in Arkansas, they were the ones who really pushed this resistance to change. It's like, who said famously, segregation today, segregation forever, who was that?
George Wallace.
George Wallace,
Alabama.
one of these people who was elected. Actually, I think he was originally elected before Brown as a racial moderate, and then he wasn't.
He was elected in '63. He actually gave that during his inauguration. Yeah.
Okay. So
we'll actually talk exactly about that speech on Thursday. So it's great.
So on Thursday we'll talk about this. I do believe that in his earlier political career he wasn't so crazy.
No, he ran for governor in '58. He was much more moderate, and then he saw kind of Little Rock Nine and other things that had happened. And
right. Okay. So let's break you up into. Oh, okay. All right. Let's quickly. This is all stuff that was. Robert, could you please read through here at the top?
These scholars point to the fact that desegregation is very violent.
So that lacks a verb. Became very violent. Okay. So the second one here, Henry. The second point here.
They also note that the pendulum has swung back. Schools are once again very separate. Cities are segregated too, and there's an achievement gap.
Okay, so this gets back to what we talked about in the warm-up, right? So today, even without de jure, legally based segregation, we still have schools that are, like Hill House. I mean, what percent sort of non-white is Hill House? I actually don't know, but what's that? It's a certain kind of high school. So when I was, I told you I worked for DC Public Schools. We had a school called Ballou, another school called Anacostia, and they were like 98 to 100% African American, and the other 2% were Latino, right? And it wasn't like that was the law that it had to be segregated. That's just how it was because of the way people were living. And these schools were and are terrible places to try to get an education. The achievement gap, as we're talking about here, like those schools did not produce good test results. But who hasn't read it a little bit? DT.
Others observed that students who attended integrated schools seemed to feel positively about immigration. Also, that Brown was an important symbol.
Okay, so even though we have a lot of de facto segregation today, people can still make the point that Brown was a very important signal, and that we do have some integrated schools, right? Okay, so all right, that was a